Welcome to day 2 and the first full day of our conference, examining whether the future of international criminal law is domestic. And I'm very pleased to see our moderator, who is all the way from Senegal. Thank you, Aminata Touré, the former Prime Minister of Senegal, and very active still in Senegalese politics, which is why she could not join us this week. She will moderate the panel number 1, what is the current state of play with cases on the national level, including universal jurisdiction cases, discussing challenges and innovative approaches. Now I will turn it over to Madame Touré to introduce the panelists who will speak, and then after we will open it at Mrs. Touré's direction to the floor for any questions or further discussion and comments. And just one small note, if everyone could please silence their mobile phones, not looking at anyone in particular. Thank you very much, and I look forward to a wonderful discussion. Thank you.
Thank you, Jenny, everyone, glad to be with you. We do have, for our first session, 4 distinguished panelists. I will introduce them one by one. Just to say that they will have a Sudan case with Ambassador Stefan Raab. Good morning, Ambassador, whom I met here in Dakar, and he has been very, very active also in Africa. Ambassador Stefan Raab is Senior Visiting Fellow of Practice with the Blavatnik School Institute for Ethics, Law, and Armed Conflicts Program on International Peace and Security, Fellow at the United States Prevention of Genocide, Justice, and Accountability to 2015, Global Criminal Justice in the United States Department of State. During his tenure, he traveled a lot, more than 1 million miles to 87 countries to engage with victims, civil society organizations, inviting leaders of government and international bodies to further efforts. This Ambassador Raab was also, and he'll talk a lot, I assume, about that experience. He was the chief prosecutor of the Special Court for Sierra Leone from 2007 to 2000, Liberian President Charles Taylor. From 2001 to 2007, he serves as a senior trial attorney and chief of prosecution at the ICTR, where he headed the trial team that achieved the first conviction in history of mass media bosses for the crime of direct and public incitement to commit genocide. Ambassador Raab, the floor is yours.
Well, thank you very much, Madam Prime Minister, and it's really good to be in the building with others. Klaus, a great center here that you've established. I remember that Mimi just talked about how I travel a lot, and I in fact did visit here twice during the pandemic in October of 2020 and again in September of 2021. I think you and I were the only live participants in some webinars from here, but you can't keep me from traveling. That's the fundamental thing. And the figure is, in fact, 1.5 million miles when I was ambassador at large. And of course, we're thrilled to have my successor, Beth Van Schaack, here today on her first trip. It'll be a 2-weeker, and we'll be together next week in Geneva as well. I did want to, launch by talking about what I've described as really a kind of a new ecosystem that's been developed for criminal justice accountability in the world. And it requires you, I think, to take a little different perspective than has been taken in the past when these things were thought of as being driven by public prosecutors to a large extent, driven by great power decisions as the International Military Tribunal and its trials in this courthouse. But that basically we really have an ecosystem now, and it's developed largely since the Syrian crisis, and since we didn't have the ICC involved, we didn't have an ability to prosecute people, certainly at the national level, because the regime itself was deeply implicated in the crimes. And that really required the development of a system that relied to a much greater extent, and there's always been great reliance, and Reid can talk about Chad and the Habre case, on civil society. But to a large extent, what we have in Syria is a large extent a reflection of the investigations that have been done, increasingly professionally, by civil society organizations with support of various governments. And so, and even as we've gone forward into situations where there may be some ICC jurisdiction, like Myanmar, or certainly Ukraine, where there definitely is, and even there are a very active national prosecutor, this sort of sense that we really have to look at the source of the information, being the victims and the affected societies, and the various groups that are now increasingly professionalized, using modern tools and mining the social media, both for information about hate speech, but also for messages that in fact, and even photos that implicate the perpetrators, and the ways in which working with partners on the ground, even in conflict zones where UN investigators could never go, and certainly the ICC couldn't go, we're bringing out evidence like that we have at CIJA, which I chair, and Bill Wiley, the director, is here. We have 1.3 million pages of Syrian regime documents. That's because there are 45 Syrians working with CIJA, and they're on the ground, and they were in places when various security centers fell to the opposition, sometimes only temporarily, and possible to bring out really the strongest documents that we've had. In some ways, when you combine that with the Caesar photos and the work of the Caesar group, better evidence than we have even at Nuremberg. And then, of course, we want to acknowledge, obviously, we've got organizations like the Syrian Archive that will be represented here later in a panel. It's done a fantastic job in terms of verifying all of the images, the YouTube videos, dealing with the metadata, verifying and using and bringing really, I think, more than 3 million videos into that process. And then the groups that have really focused on the victimization, like the Syrian Network for Human Rights, that can actually name 129,000 people that are missing. So this has all been developed, and it's so much stronger than we've had in other situations where in fact we've had international bodies involved. I remember being at the ICC Assembly of States Parties, a meeting of a side event during that. I think it was in December of 2019. Catherine spoke, and I think one diplomat who came from a very like-minded pro-ICC country said, you know, we're probably further along in Syria today than we would be if the ICC had had the referral in 2014. And I think it's a reflection of that engine that we've had. At the same time, then, of course, we've had Commission of Inquiry, which has done the great job of reporting on the pattern of violations on all sides, but a recognition, and we have to thank our Liechtenstein friend, Christian Veneweser, the longest serving ambassador in New York now in his 20th year, for leading the efforts in the General Assembly to establish the mechanism that Catherine now heads. But important as you look at the terms of reference and as you look at the resolution, it largely is a resolution that calls on that body to consolidate the information, to bring it forth, to verify it, to collate it, to analyze it, to use to build it into cases in a more neutral body than you would have with any of these NGOs, or as I call them, evidence-producing organizations, and really with a focus particularly on then working with national systems and prosecutors like those here in Germany, and the team led by Christian Richer, who's now going on to UNITAD, who's done this fantastic job in bringing forth universal jurisdiction cases. First genocide case, frankly, in Europe, this case out of Frankfurt involving the conviction of an individual, the killing of a young Yazidi child of a sex slave, but it was possible to win a genocide conviction there. And then additionally, the great work on the Syrian regime cases in Koblenz and Frankfurt and Berlin, cases that are going forward. And so I think we have to look at the various elements of this ecosystem, the sources of that information, the multilateral bodies that need to be enabled to bring that material together and to add to it and to fill the gaps, to engage in both the reporting and the case building, and then the national prosecution authorities that are bringing forward the cases. And each part of this ecosystem, from upstream to downstream, needs to be cultivated and nourished. And that's why, even though I'm going to Geneva as part of a process that I've been heading together with Federica D'Alessandra at Oxford, and now in cooperation with the German government, as they're looking at the establishment of a standing mechanism as a G7 initiative, that we need to work together to recognize that even if we get a standing mechanism, we need to strengthen the other parts of this system as well. It won't be sufficient to say, we've got a standing mechanism, now we don't need to support the Syrian archive anymore, or we don't need the resources for JITs, or whatever is happening at the national level. And so each part of the system, I think, is essential. And I think as we go forward, the importance of, in other situations, even where we have the ICC involved in working with groups like Truth Hounds in the Ukraine and the various civil society groups that are bringing together the material often out of these communities where people are being shot, where there are horrendous war crimes committed, torture and sexual violence, like in Busha. The evidence is coming in those situations from people that have taken it on their own videos. At the same time that we look at strengthening that in these situations where we have a national prosecution with jurisdiction, again, we've got to focus upstream in making sure that they have the resources and the forensic knowledge and the skills to do an effective job. And I'm pleased that the US and the EU and the UK have come together in a process that's, I think, called the Advisory Group on Atrocity Crimes, that then is assisting the prosecutor. And this was announced on Wednesday. It's a program actively supported by my former office under Ambassador von Schack, to provide for prosecution mobile teams with international involvement to get out and find the evidence that will be of particular relevance in these criminal proceedings. But it's all a matter of putting, I think, a great deal of emphasis sort of, as I say, upstream to the places where the victims are and where they're seeking justice and where the true information is. And then as we look at the UN system, and this is the focus of the German initiative and of the report that our Oxford project, in cooperation with the Holocaust Museum and the International Bar Association, will enter next week. I think we do need to look at having a standing mechanism, separate from the Office of High Commissioner, that focuses definitely on the issue of case building, that can receive mandates when there's a need for a mandate, whether it's Ukraine or Sri Lanka or South Sudan, et cetera. Of course, already we have commissions of inquiry in these situations, and sometimes already with mixed mandates, both for human rights reporting and criminal justice. But this body could both take mandates from, say, the General Assembly and do the kind of work that Catherine and Nick and Christian are doing, but that can also provide assistance to those inquiry mandates, whether we're talking about the one that Betty is on and that Fatou chairs for Tigray and Ethiopia, where they don't have at the moment adequate resources, they don't have a forensic team, they don't have the ability to get in there and really do the work. I mean, it's parts of the difficulty of having the budget of the High Commissioner constantly just torn apart in New York. But at least these mechanisms have been able to get some substantial resources. And so making sure that those inquiries that are established have those kind of case building skills is, I think, a profound unmet need. And I think there's actually movement now to do it. Of course, that could also be assisting the commission chaired by Beric Mosa, in which our friend Pablo de Graaf and others are involved in Ukraine. So that's a sort of mid-step. And then when we look at the prosecution, we have, of course, the example here in Germany of an extremely aggressive prosecution system, 2 units in prosecution, 2 in the BKA that are doing this very strong job with a universal jurisdiction statute with structural investigations. But if we look elsewhere, we find it's very difficult to get cases going. Statutes are extremely limited. The sort of opportunities to prosecute directly for the crimes that have been committed abroad, even like, for instance, in my own country, where when a genocidaire or someone involved in these atrocities appears, we're often almost always limited to charging them with immigration fraud, a paper violation, and not with the crime itself. And so there really has to be a focused effort on making sure that our national statutes are there, and that we also maximize things that Mateos was talking about yesterday, cooperative efforts between prosecutors, so that each country can be doing the cases in which it can be most effective in a more strategic approach. Finally, and we heard yesterday also the issue of coordination, and who to coordinate all of this is I think, a large challenge. And in a situation where perhaps the ICC is involved, it may be able to perform that role, but of course it's only going to be involved in a limited number of cases. And it may be that, just as people have said about OSHA, or the humanitarian office, that this standing mechanism can potentially be involved in that coordination issue and ensuring that the resources are brought to bear and that things are done in a strategic way, and that it's not a passive system, but in fact an active one, which will ensure that even to the extent that we don't have an international court involved, we have ways to achieve accountability for these victims and really live up to the Nuremberg principles. And as we had all hoped, who became involved in this process, in this whole project since the end of the Cold War, really do have something closer to a system of global justice, where there is the perception among leaders that if you do the crime, you may end up having to do the time, and that we can begin to protect people through this system of criminal justice. So I brought it trying to put a lot of things together that many people don't think hang together. But if you think about this as an ecosystem that really needs to be strengthened in every part, then I think we've got an agenda for the next several years. Thank you very much.
Thank you very much. Bringing about the complexity that we really face one as an international community, whether it's the UN or multilateralism partnership we face in supporting this ecosystem. I think it's very important that you pointed out that although we may be acting at national level, we really need to come together as an international community to support those cases. So thank you very much. I will move to our second speaker, Owiso, who is a lecturer at the University of Groningen. Owiso is a lecturer in public international law at the Faculty of Law. He's also currently finalizing his PhD in public international law and international criminal justice at the University of Luxembourg. He is a keen observer of and regular commentator on international courts, particularly the ICC, Internationalized Criminal Tribunal, and the International Court of Justice. So, Owiso, the floor is yours.
Thank you, Dr. Toure. The thing about being on the first panel of the day is that everybody is almost alert and you're expected to say something sensible. It's a bit of a hostage situation over here. And looking around the room, I see people who have shaped and continue to shape the international criminal justice landscape. It's intimidating, but most importantly, it's very inspiring. So I'm honored to be here, and I hope I get to say a few things that make sense to you who know much more than I will probably ever know. So I'm going to spend the next couple of minutes discussing or addressing two arguments that I consider as innovative approaches to international criminal justice. The first being that if the international criminal justice project is to have a future, in my opinion, then I think we should identify and harness and consolidate the universal jurisdiction potential of those states that are normally closest to the locus states, those states that are within the region or neighboring states. And then my second argument would be that there is significant potential in regional intergovernmental organizations that can be utilized to promote accountability within states themselves or at a regional level. So my first argument, I observed that one striking aspect of current universal jurisdiction conversations is there's much focus on prosecutions in European states and to some extent a little bit, of course, in North American states, which are reported with a lot of gusto and a lot of enthusiasm. There's nothing per se wrong with that. In fact, I believe that this is actually a very good thing because in most of these situations, these universal jurisdiction prosecutions in European states are the only avenues for accountability where none otherwise exists. However, the problem therein is that there's very little, if any, effort that goes towards discussing or advocating for similar prosecutions within the regions where these crimes occur, either within the neighboring states themselves or within the regions broadly. And I think that this is something that we need to have a conversation on. And the fact of contemporary conflicts, contemporary situations, is that most of these perpetrators do not make their way to European states or North American states. In fact, looking at the current landscape, Europe is tightening its financial controls, its immigration controls, so it's going to be a little bit more difficult for these persons to actually move to North American states. Majority of these persons remain within the region, and they have lots of leeway to move across borders within the neighboring states. For instance, there's significant evidence that in the South Sudan situation, most of the persons who are alleged to have committed international crimes in South Sudan from 2013 to date, most of them have very strong social and economic links in neighboring states, particularly in Kenya and Uganda and Ethiopia. They live there, they have families there, they have investments there. The same applies to situations such as in Myanmar. There is evidence that quite a number of low-level and mid-level junta members, Myanmar junta members, move quite freely across the Bangladeshi border. Some of them have been spotted in Cox's Bazar, not sure what they're doing there, but probably spying on their victims there. And the same applies, particularly, let's say, the Syria situation, where quite a number of these persons move quite freely within the Middle East. So I believe that there is a conversation that we can have there. It is imperative, in my opinion, that universal jurisdiction advocacy pays as much attention to lobbying for prosecution by neighboring states or within these regions, in addition to the fact that these states are more likely to net many suspects because these suspects are just around somewhere there. There's also the assumption that these states have more what I would call socio-political legitimacy because of their close connection, geographic or social or political, with the locus states. The surest way to make sure that the universal jurisdiction is effective and sociologically legitimate is to encourage, active engagement by these states who are otherwise, currently inactive. I therefore propose that the first steps towards promoting this shift in conversation is to identify and harness and consolidate the potential of these states. Of course, admittedly, there isn't much in terms of universal jurisdiction practice within in these regions and within these states. However, a fundamental part of building this state's capacity for universal jurisdiction prosecution is to identify the imminent practice that they have, as little as it is, that they have with regard to universal jurisdiction or related concepts such as piracy prosecutions, for example. So in this regard, I would echo what Dr. Toure said yesterday, that we should see the glass as half full and not half empty, a little bit of optimism. So I would point a few examples of what I consider as relevant practice that we could identify and take it from there. For instance, the African Union's experience with his and Habre that was discussed in significant detail and sufficient detail by Dr. Toure yesterday. During the back and forth between the AU and Senegal on how to go about it, the panel of experts appointed by the African Union recommended that his and Habre could be prosecuted by any member state of the African Union exercising universal jurisdiction. And Rwanda stepped up to the plate. I believe we have some representatives from Rwanda. Rwanda offered to actually prosecute his and Habre when Senegal was dilly-dallying. And in addition to the many factors that eventually led to his and Habre being prosecuted, I'd want to believe, at least I'm a bit of an optimist most of the time at least, I would want to believe that the fact that Rwanda stepped up and offered to do this played a little role in getting Senegal to step down from its intransigence, and eventually we saw his and Habre was prosecuted. I'm glad to see Dr. Toure here and Reid, who played a significant role in that process. Again, I'm starstruck, both of you. Yeah. Then there's of course the African Union model law on universal jurisdiction. There's not much has been written on that. I think that's a challenge for some of us who conduct research to write more on this, and then of course have a lot of discussions on that. A number of Bangladeshi scholars have written quite impressively on the practice, or the universal jurisdiction practice that Bangladesh has, because it's actually used this before in a few cases on war crimes. And they've made very convincing, at least in my opinion, arguments that Bangladesh's imminent practice on universal jurisdiction with war crimes could actually be tapped into in order to ensure some measure of accountability for the Rohingya population, because as I said at the beginning, there is evidence that most low-level and mid-level junta members cross quite freely with the border between Myanmar and Bangladesh, spying on their victims across the border in Cox's Bazar. Then, of course, there's also a significant body of jurisprudence on piracy, which is a related concept, I believe, particularly from states such as Kenya and Nigeria on how to prosecute piracy. So I think there's something that we could learn from that, from the fact that they've been able to successfully prosecute piracy and project that onto other international crimes. I therefore propose that while we rightfully applaud ongoing universal jurisdiction in European states, and congratulations Germany, you're getting there, that is pretty good, we need to applaud that, but at the same time, we need to dedicate as much energy and enthusiasm towards encouraging these other states that are closer socially and geographically to the local states to actually step up, identify what they have, and then we go from there. The importance of doing this is so that we can first identify the good practices that exist, however limited they may be. We identify the shortcomings and possible corrective measures, and then we use these as proof that indeed these states can actually exercise universal jurisdiction if they're sufficiently motivated to do so. And finally, we can use this as a basis for spurring momentum for wider application of universal jurisdiction by domestic courts that are closer to the victims and closer to many of the perpetrators. So that is all on my first point, but so on my second point, which I mentioned earlier, on regional organizations. The International Criminal Justice Project, to me, appears to have spent the energy that we had, towards the end of the 21st century. I think that momentum, that energy for global initiatives, it's waning, I think, despite the fact that, there are many international crimes that continue to stay in our 21st century landscape. Global action is waning. The appetite for global level responses is waning, and of course, that's a very unfortunate situation. And to compound this state of affairs, the international community appears reluctant to imagine other possible institutional arrangements outside those traditional global level administration of international criminal justice. I believe that times like these, when global consensus is elusive, we require little imagination on which other actors we may have out there. And in this case, in this particular regard, I argue that regional intergovernmental organizations have the potential that we could actually tap into so that they can step in to fill this impunity gap that is left by a faltering, global level response systems. So regional organizations can be instrumental, in my opinion, either in supporting domestic prosecutions within member states or by themselves establishing ad hoc mechanisms. I'm aware that quite a number of people in the field, of commentators and researchers in the field, do not quite fancy the idea of ad hoc mechanisms anymore, but I believe that we cannot do without them. Just because we have a permanent international criminal court, we know all its limitations, so I still would argue that ad hoc mechanisms are still a way to go, but in this instance they could be led particularly by regional organizations. There are examples of regional organizations being very assertive in this regard. I'll just point out a few of them. ECOWAS, for instance, has single-handedly redefined what I would consider, what I would call pro-democratic interventions in the region, in the West African region, in its member states. Of course, that has raised quite some concern as to its compatibility with the Security Council's powers under Chapter 7 of the UN Charter, and the consistency of that and the success rate of that is also questionable, but ECOWAS has proved quite assertive in that regard, right? So I do not see any reason why this assertiveness cannot be extended to supporting international criminal accountability mechanisms within ECOWAS member states, starting with the Gambia, for instance, where former President Jammeh is hiding just somewhere within the region. So I don't see why ECOWAS cannot extend its assertiveness that it has proven in terms of pro-democratic intervention towards international criminal accountability issues. Another example I would point, again, of course, that I mentioned earlier is the successful prosecution by Hissène Habré, through efforts by the African Union and many others. Of course, that has been, won't belabor that point, it was sufficiently discussed by Dr. Toure yesterday. And the African Union has currently, at the moment, been tasked with establishing what I would call its first ad hoc mechanism, if it ever gets established. That is the proposed hybrid court for South Sudan, which I'm one of the few who actually believe that it will get established someday. These things take long, and Dr. Eva Vukusic is here, who's argued that there's something about time. As much as, when we say that justice delayed is justice denied, it's not always the case, not necessarily the case. It may take time, but there's something there. Even if it takes long, there could be a good reason for that. It gives us time to gather evidence. She's right here, she could make those arguments better than I can. So I believe that the proposed hybrid court for South Sudan, at the moment we see that there's not much movement there, but I believe that if, with sufficient motivation, with sufficient advocacy, the African Union can eventually actually move forward with that particular process. Closer to the continent where we are at the moment, the Council of Europe was instrumental, I believe, in the process that led to eventual establishment of the Kosovo Specialist Chambers, which is currently based in The Hague. The initial investigation into the crimes allegedly committed by the Kosovo Liberation Army were conducted by the Council of Europe, which later on, of course, passed it on to the European Union to take it forward. But because of the current situation, what's going on with Russia and Ukraine, I think it's important to note, as an anecdote perhaps, that the Council of Europe's initial investigation was actually spurred by a Russian member of the Council of Europe's Parliamentary Assembly, Konstantin Kosachev, I believe that's his name, who tabled the motion before the Council of Europe. So, as they say, what goes around comes around. So I do believe that the Council of Europe has some experience to some regard in regard to this, and I have argued in, I believe, a blog post that I published a few weeks back or a month or so ago, that the Council of Europe can actually take the lead in assisting Ukraine to establish an ad hoc tribunal for the specific crime of aggression. I am not the only one who's made that argument. It's been made by quite a number of others, some of them who are in this room. So I believe that the Council of Europe could actually be one of the regional organizations that actually steps forward in filling the impunity gap that exists, in the sense that the International Criminal Court cannot do anything, jurisdictionally speaking, in respect to the crime of aggression. Then the last example would be the obvious one, being the European Union and Kosovo Specialist Chambers. The Kosovo Specialist Chambers, currently sitting in The Hague, is successfully undertaking trials of former Kosovo Liberation Army members, largely because of the efforts of the European Union and, of course, the Council of Europe through an international agreement. I highlight these examples to show that this is not an entirely new terrain for these regional organizations. Some have dipped their toes in the water, so to speak. They've dipped their toes in the water, but they are reluctant to swim. So what I believe is needed is we need to nudge them. They need a little encouragement. Nudge them to take the plunge, right? Because they could very well, I believe, be our last hope against total impunity, seeing as global multilateralism has all but collapsed. So in conclusion, my response to the question posed by this conference, the question being, is the future of international criminal law domestic? I would say this: I'm not much for sloganeering, but I say we should be innovative in our approaches to criminal accountability. Moments of crisis call for legal imagination and legal creativity. We should treat international criminal accountability like vectors in mathematics. I was not a very good student of mathematics, but at least I still remember vectors, right? So there are multiple routes. They could be national, they could be regional, they could be global, but all should ultimately lead to the same outcome, which is accountability. This way, we may very well overcome what, again, Dr. Vukusic, who is here, calls a malaise in the international community. That is a lack of vision and optimism. I thank you for your attention. I think I should stop there.
Thank you very much, Viso. I think your last word is the one that comes to many people's mind in this context: optimism, and have to keep it. I think you're very, very right to point out the need for knowledge sharing and good practices sharing, because many of our countries from this part of the world, in the African continent, are still building their competencies and their systems. So there is very much a need to work together. And the idea of a regional organization is something we need to think about very, very profoundly. We do have many tribunals here in West Africa, and as you said, they have cases on democracy. So the whole idea is, how can we extend their mission? So that is something that we need to think about and pursue to think about. Thank you very much. So let me move to the third speaker, which is Madame Rina Devgun, coordinator of the War Crime Prosecutors at the Swedish Prosecution Authority. Rina Devgun currently serves as Senior Public Prosecutor and Coordinator for the Swedish War Crime Prosecutor at the National Unit Against Organized Crime within the Swedish Prosecution Authority. She has been working as a prosecutor for the last 13 years and with Core International Crime since 2014. She works almost exclusively on investigation related to core international crimes committed in Syria. She recently received a judgment in the first Swedish conviction of war crime relating to ISIS, use of child soldiers. She is also the lead prosecutor in the Swedish structural investigation related to ISIS, which is part of Eurojust, joint investigation team with France. She specialized in international law and international humanitarian law, and as part of her court clerkship, she completed an internship at the ICTY Trial Chamber 3 in 26. Madame Devgun, the floor is yours.
Thank you, Your Excellency, and thank you for having me. I think I'm here to give some sort of a practitioner's view from a national jurisdiction. I think that Dusha gave a very vivid account on what Germany is doing. Sweden is a much smaller country, but with a quite big, in comparison, than War Crimes Unit. We have 12 appointed prosecutors and standing unit within the police investigating core international crimes. I'm here to talk about the state of play and also, I think, innovative approaches. I would say that there has been a rapid development when it comes to domestic prosecution of core international crimes. The long-standing war crimes units in Europe, which Sweden has one, would go from dealing with cases, I would say, in the aftermath of the tribunals, that is, we were taking on cases after the ICTY and ICTR. Sweden, for example, tried its first cases of international criminal law in relation to the wars of former Yugoslavia and the genocide in Rwanda. All of these cases were related to Swedish citizens, and I think that's important to remember. There was a Swedish link. Yes, we are exercising universal jurisdictions, but these were people we could not extradite, and we were dealing with them because we had under international obligation. I would say that those cases, they were challenging for a Swedish court and Swedish investigative units. I mean, we had not, many of us probably not been in Rwanda, there would be cultural differences. But at the end of the day, when it came to the legal matters and the legal requirements for the crimes, a lot of that had already been dealt with within the tribunals. So there was a lot of jurisprudence we could lean on. A lot of questions had already been answered. Then I would say Syria happened, and that kind of changed the state of play for us. The Syrian conflict led to a massive refugee stream into Europe. Millions of refugees sought a safe haven. In Sweden, we received about 100,000 Syrian refugees during 1 year. And this brings me to a point which Mateusz was talking about yesterday, that when it comes to successful countries of these areas, there is a need for a standing investigative unit. Now, these investigative units, they will have the ability and capacity and will to do something. But I think what's most important as well is not that they only have the will and capacity. The fact that they're standing gives us a little bit more of liberty to be creative. We're not just waiting for a case like a recipient. Someone's telling us that you have this national, you can't extradite him, you need to deal with him. The Syrian situation gave us the time, basically, to sit down and discuss what can we do from a Swedish perspective. And what we did, we initiated a structural investigation. This was inspired by Germany, but we did it with a very Swedish perspective. I think many of you already know what that is, but I would like to give you a little bit of a closer definition, because the structural investigations, they're quite different. They're not all the same. They can have a different purpose. In Sweden, the first one related to the Syria situation as a whole. The aim was to gather evidence in Sweden. That is, we would conduct interviews of key witnesses. We would not interview all 100,000, and that number was increasing, refugees coming to Sweden. We do not have the capacity or resources. We would look for key witnesses and the evidence which is best preserved by a national authority. That could be a doctor at a hospital receiving patients from a chemical attack, but it could also be a victim of a rape, because when it comes to evidence in trial, it will be that testimony that will be the most important, that we need to secure and preserve. And we thought, and we still believe that, and that goes for all conflicts, that when it comes to preservation of testimonies, I'm not saying that we are the ones that should do it, but if a national jurisdiction can preserve and obtain the evidence, that's the best way to do it, because we can preserve it for a coming trial. And when it comes to using evidence in court, it would always be best if it's conducted or obtained by a police unit. And this is just a very practical view, but it's also very true. With that said, I'm fully aware that this is not the situation in any conflict zone, and I will come to that, because even though the first Syrian structural investigation in Sweden related to the victims and witnesses in Sweden, the second one didn't. Because what we did in 2019 was to initiate, or actually we divided the structural investigations to one only relating to ISIS. Now, the ISIL structural investigation, the aim was not to secure eyewitnesses and victims in Sweden, because we do not have that many victims of ISIS crimes, at least not when it comes to the minorities and the crimes of genocide and slavery or crimes against humanity. The idea was that Sweden had about 300 foreign terrorist fighters traveling to the Syrian and Iraq war to join ISIS. And even though we couldn't say just by believing that they had committed a core international crime, we could say that the crime base in the context or in the conflict zone was so immense that it could be likely that they would be either perpetrators or witnesses of these crimes, which meant that we would want to secure evidence in relation to Swedish individuals. So still a response that aimed at taking a national sort of responsibility for these offenses. So the idea with the structural investigation relating to ISIS is actually to identify Swedish or European FTFs among the perpetrators of ISIL crimes against the Yazidi minority. Now, I think the speak from Oviso here about regional units is really important. I agree that the war crimes units within the EU are not we're not the only solution. I think what we hope to do is to be inspiring of how things can be done, because I think the importance of having a regional network where we could exchange information is vital for the work we're doing. And what we did, because also when you look at the foreign terrorist fighters going from Europe, we could see that there is an interlinkage between them. In the conflict zone, many of them were friends, they're married to each other. A Swede would be married to a British, to a German, or a French. And we realized that the information that we have with regards to our own perpetrators, or at least FTF fighters, needs to be coordinated, and we need to in some way share this information with the ones holding information of the victims, because there has been an enormous collection of testimonies. And to give you a very concrete example, a victim of slavery within the Syrian context or of ISIL crimes, they would not really know the real name of the perpetrators. They would know their kunya or the war crime, but they would know how many children they had, how many wives. They might know that the wife was foreign, what they looked like. And if there's something that intelligence units are good at, it's keeping track of their FTFs. In Sweden, there has been a very clear division between the counterterrorism units and the war crimes units. And the information is not just easily shared. So we had, within our own national jurisdiction, start a cooperation to obtain more information. Because once we did that, we could see that the already gathered information from the victims needs to be cross-checked with the information within the national jurisdictions. And this evidence is not interchangeable, and no one can sort of replace the other. And what we did was we called for a meeting within the Genocide Network with several countries to discuss this matter. And this evolved to the JIT between Sweden and France, and in close cooperation with the UN mechanisms, and especially UNITAD, we have been able to coordinate the information we have with the information obtained by these mechanisms. One specific example is that, and I thought that was interesting with what Karim Khan was saying yesterday, is to take one step further in actively trying to identify perpetrators. This requires a lot of analytical work of these testimonies to see who knew who, not only within the perpetrator FTF group, but also within the victims group. And I would say that for us, this is the best example I have seen in years of interlinkage between a UN mechanism and national prosecution, because we are completely relying on the help of UNITAD to be able to do this. And we are, by doing this also, it has enabled us to conduct coordinated interviews with victims, which means that basically we are not re-traumatizing victims by interviewing them, each country, one by one. I mean, if Sweden has an interest of one Yazidi victim, it's very likely that a lot of other European Union states would have the same interest because of the FT group's connection. And this is an effort. We're still at the beginning, but it has led to results. And I can't give you too many details, but we are in the beginning, and it's an approach where we are moving from just waiting for one identified perpetrator that we will prosecute to actually take responsibility to identify perpetrators within our own national jurisdiction. Now, Sweden does not only investigate the Syrian conflict, of course, and I think that's important to stress that these national units, they can be they're able to stand by when the situation occurs. We just finished a trial in Sweden relating to an Iranian citizen. He was accused of a state-sponsored execution in the final phase of the 1980s Iran-Iraq war. That 9-month trial was just finished last week, and the judgment would be in mid-July. This is probably the case in Sweden where we have been closest to exercising a pure universal jurisdiction, yet this person was on Swedish territory when he was arrested. We also have an indictment that was launched in November of aiding and abetting or complicity of war crimes against 2 officials of a Swedish oil company, Lundin Petroleum, in Sudan in 1990 to 2003. This investigation has been going on for 10 years, and I think the court documents are already up about 80 to 100,000, and this trial will last over years, probably, when it starts. On top of that, of course, we have several ongoing investigations relating to Syria, and as mentioned, we had our first judgment relating to a child soldier. And what's important as well is that in Sweden we do not have the crime of membership of a terrorist organization. I think we're one of 2 countries in the world that don't exercise that. This will change in the future, but we will not be able to use this offense for the Syrian context, which meant that judgment was only for core international crimes. Sweden was also the first country to render a judgment relating to the Syrian context. So it was a Swedish court that had to decide, it was a small Swedish district court that had to decide that there is a non-international conflict in Syria for the first time ever. And I think that's important to stress, that even though we do trust these tribunals to do very diligent work in doing the assessments of these quite challenging legal matters, I think that we have come so far that even a national jurisdiction can deal with quite difficult matters. So to finalize, to come to the question, is the future of international criminal law domestic? No, it's not. Because as it is, with these existing units, we will do our part. We will investigate, we will prosecute, but there will be some sort of limits, there will be a national link to it. And there will be rather low-level perpetrators. Even though these cases can be huge, they can be quite consuming. And I also believe, with that said, that the strongest deterrent for committing these crimes is to hold the senior leadership responsible. But I agree with what Lisa was saying, that you need to have a legitimacy to do it. I think national jurisdictions, could we do it? I remember when ISIS fell that there were discussions of a super JIT. And probably, yes, if Sweden, Germany, the Netherlands, and France would go together, we could probably do something. But should we? Well, when it comes to the notion of justice and prosecution of senior leadership of a state, I think any idea of bias or interest should be reduced. And I'm not saying that any national court has that, but I think it can be perceived as that. And I think all of the tribunals, the ICTY, the ICTR, but also the ICC, has been criticized for being biased or impartial or taking one side. But that will always happen. I just think we need to work for reducing the risk. And I think a national jurisdiction dealing with the most senior leadership of any country or any context, if it's not the situation country, will be difficult. And I don't think it's something we should aim for. I think that the ICC should be used for this purpose. And if it cannot be used, there should be some other alternatives. To finish, I strongly agree with what the Karim Khan said yesterday, the prosecutor, that there's not a competition between the national jurisdictions and the international tribunals. It's more a question of coordination among the parties of like-minded. And I'm very optimistic about the future because I think there has been a change where also national jurisdictions are looked upon as someone who could actually assist international tribunals and not only the other way around. And I will close at that. Thank you.
Thank you very much, Ms. Devgun, for sharing this Swedish very practical experience, particularly in gathering evidence in Sweden. And I do very much agree with you that the interlinkages with different like-minded, including the UN and national and sub-regional mechanism, as he was said, could really support national jurisdiction. So thank you. It's now my pleasure to introduce my friend and co-conspirator, I would say, Reid Brody. Reid Brody is currently serving his first term as a jurist at ICJ, having been elected in December 2016. He is counsel for the victim of the former dictator of Chad, Hissène Habré, who was convicted of crimes against humanity in a special court in Senegal. Previously, he worked on the cases of Augusto Pinochet and Jean-Claude Baby Doc Duvalier. From 1998 to 2016, he was counsel and spokesperson for Human Rights Watch. He has also served as deputy chief of the UN Secretary General Investigative Team in the DRC. He's been a director of the Human Rights Division of the United Nations Observer Mission in El Salvador. He has been also advisor to the government of Haiti for the prosecution of serious crimes and executive director of the International Human Rights Law Group. From 1987 to 1992, he was director of the ICJ's Center for the Independence of Judges and Lawyers, and then ICJ Executive Secretary. His 1984 investigation uncovered atrocity by the United States-backed Contras against Nicaragua's civilians. He has taught courses on accountability for international crimes at Columbia Law University and the American University Washington College of Law. So Reid, the floor is yours.
Thank you, Aminata. First of all, I want to pay back just a little of the compliments you paid me yesterday. Mimi, as Hurricane Mimi, as she is known in Senegal, was very modest. Hissène Habré's victims were in the wilderness for 13 years until Macky Sall was elected president of Senegal, and Aminata was made Minister of Justice. And as she described how her assistant called me a crazy white man who was always always bothering the ministries of justice. Well, prior to Mimi, 13 ministers of justice would basically walk out the door when they saw me coming. And Mimi was the one who actually called me and said, how do we get this done? And she is our hero. I have, this is not a shameless plug, but I have a book coming out later this year in which I list, it's not an academic book, it tries to be kind of a thriller, but in the end, I have acknowledgments in which I have 4 diplomats who I pay homage to, and Mimi is the first one. One of the others is sitting right next to me, who not only went to Senegal, he went to Chad, he flew across the continent to a donors meeting, he got the US government in line, so it's for me a real pleasure to be here with both of you. Just for curiosity's sake, the other 2 are our friend Gerard Dive from Belgium, who helped the Habré law survive the collapse of the Habre case survived the collapse of the Belgian universal jurisdiction law. And the other one is Ben Kiyoko, who is the legal counsel for the African Union, who also made this happen. I want to talk about three things, some of them picking up from what Owiso said and what Mimi Torre said yesterday. One is double standards. The other thing I want to talk about is giving victims a greater role in universal jurisdiction cases. And thirdly, I want to talk about outreach. I mean, we can complain about the security, about double standards at the ICC level, which are, of course, in part a result of the non-ratifications and the Security Council veto. But we can't, but if the future of ICL is going to be domestic, we have to avoid replicating those double standards at the national level. And I'm not going to go over here because we all know what happened to the Belgian universal jurisdiction law, which was fine when it was going after Rwandans, but when it started going after the United States, I was there when Donald Rumsfeld came and basically told Belgium to change its law. The same thing with Spain's universal jurisdiction law, which was great for Pinochet, it was great for El Salvador, it was great for Rwanda, but when Israel, China, and the United States were targeted, that law also collapsed. Here in Germany, which now would appear to have the best universal jurisdiction law in Europe, when Andreas' organization filed a case based on the systematic torture of Muslims by the Bush administration in Guantanamo, in Abu Ghraib, and other places. Germany took a political decision, I believe, twice, once after Donald Rumsfeld said he wasn't going to attend the Munich Security Conference, to drop those cases as well. So I think we have to look at how this is seen in the world. And unfortunately, it is seen. I've been working on the Habre case almost every day. I heard this argument thrown in my face. So Belgium is going after Hissène Habre, huh? What about Ariel Sharon? What about George Bush? And I don't think, as important as what we are doing is, and it's very, very important, I don't think we can avoid that argument. It's a wonderful moment. It's a horrible moment in the world. It's a wonderful moment for international criminal lawyers. There has never been, as today, this mobilization of international law, and it's heartwarming. It's amazing. But there's stuff happening in other places in the world. We could have structural investigations on Israel. And we don't. We could be looking at Tigray and Yemen and other places, and I think we have to be aware of these problems and use this Ukraine moment as a way to galvanize support for international justice and international law all over the world. I think the standing mechanism that Stephen Rapp and others have been pushing so strongly is one way to do that. I would argue that the standing mechanism would need to be triggered by some expert body, not again by a political decision by states, which will always tend to go in one way. Owiso talked about supporting cases in the global south, and I would say that is we can't always have the paradigm. One of the reasons Human Rights Watch back 20 years ago, 25 years ago, got involved in the Hissène Habre case was because he was in Senegal. And we felt that if universal jurisdiction was going to be truly universal, that countries like Senegal needed to exercise that jurisdiction. But it's not easy. I remember from the very first day, President Wade, or not the first day, but saying to us, we don't have the money to do this. We're going to want a Senegalese judge to go to Chad and open mass graves. This is something Belgium can do, but not us. So I think we need to be support. It's a great genocide network to support European countries when they do this, but we also have to look at the actual costs, not just diplomatic costs, which is another story, but the actual physical costs of doing that. Another way I would say of facing these double standards, which is my second point, is to give victims a greater role in initiating universal jurisdiction cases. And I know that's very scary. But let's remember that the Pinochet case, the Hissin Habre case, which are arguably the two highest ranking officials ever to be ever to have universal jurisdiction cases focused on them, were only done because of the victims. Pinochet was a victim's complaint in Spain, or together with the Querella Popular by NGOs. The Habre case was victims going to Senegal, going to Belgium, going back to Senegal. These cases would not have happened. And if victims can't bring cases, the only cases that will be brought are cases that political decisions have been made that these are the people, which again, I always say this, none of Hissin Habre's victims ever said, Reed, until we get George Bush, we'll wait. They want justice, everybody wants justice, but we have to, we have to be even-handed about this. Obviously, when you allow victims to bring a universal jurisdiction case, you're eliminating the political filter, which is what everybody's scared of. And I remember Louis Michel, when he was the former foreign minister of Belgium, he said to me, look, how can I deal with this? Other European ministers are making fun of me. How can I negotiate with a country when their leader is being prosecuted before my courts? They don't understand that the Belgian courts are independent. They think I can do something about it. Just recently, I'm on the board of a very powerful organization called Democracy in the Arab World Now, DAWN, which was Jamal Khashoggi's organization. And we have filed a lawsuit under a civil lawsuit under the Alien Tort Claims Act in the United States against the Crown Prince, Mohammed bin Salman, for the murder of Jamal Khashoggi, together with his fiancée, Khadija. MBS is demanding, now the US is going to we want them to lower the price of, as everybody does, wants them to lower the price of oil. MBS is making apparently a condition that the US government interfere in this lawsuit to uphold MBS's immunity. Obviously the political filter is very powerful, but it's only the role of victims and the hope that there's an independent judge out there, a Balthazar Garçon, a Benoit van der Meersch, that raises the hope that you can get around these political considerations. I would also say, though, that victims' participation in cases changes the entire nature of the case. I've always been very influenced by a study by Nomi Roth-Ariadza, where she looked at domestic cases, the Guatemala cases, the El Salvador cases, Argentina, Pinochet, Habre, and she said, she studied the effect of these cases on the societies, the relevant societies. And her conclusion was that they had a much greater and less ambiguous impact because of the agency of the victims and survivors. Rather than play passive roles in litigation driven by prosecutors, the victims and their witnesses and their organizations and attorneys were the driving forces behind these cases. They stirred imagination and opened possibilities. And my life, what I've been doing for the last 20 years is really, I see that. I mean, we were working on the Pinochet case. We were approached by the Chadians who said, we want to do that. Can you help us do what Pinochet's victims did? And 20 years later, when Hissin Habre was convicted and Yahya Jammeh fell, we were approached by Gambians who said, we want to do what Hissin Habre's victims did. And we had a wonderful meeting in Gambia with Chadian victims and Yahya Jammeh's victims. And it's the kind of thing, not everybody can be a Karim Khan, but anybody can be a Jacqueline Mudena or a Suleiman Gengeng or a Reed Brody. It's something that gives the power to victims and to their allies. But it also, I want to say, and this is important, changed in the Habre case, it changed the nature of the case itself. First of all, it created the political momentum for this case to succeed. I mean not to describe what in Africa they call the feuilleton politico-judiciaire, the legal and political soap opera of this case. And people in Africa, they would listen to Radio France Internationale, and they would hear Suleiman Gengeng year after year talking, and everybody was supporting them. And when we went to Belgium, and the Belgian law was being repealed, Suleiman met with Guy Verhofstadt and with the justice minister and people. And there's no Mr. Gengeng, no. He would describe to them how he was fighting, how he took an oath when he was in prison, that if he ever got out, he was going to fight for justice. And he started fighting for justice. And Senegal didn't give him justice, but Belgium had sent a judge. And now you're going to repeal this law? And the people said, no, Mr. Gengeng, we'll figure out a way. And Gérard Dive, when the law fell, he wrote a little thing there. So, okay, we got rid of Sharon, we got rid of Bush, but saved Hissène Habré. and that was not because Reed Brody. I remember when we came to see you, we went to the Congress and we saw Tim Reeser and all these people. It's not a prosecutor, it's not a Reed Brody, it's the victim who can talk to, political. In Senegal, Aminata still is being bothered by Abdourahmane Gueye, the victim. Well, it happens that there's a Senegalese victim in Chad. And this man became just a regular Senegalese guy like you would see on the corner selling stuff. He became the face of the case in Senegal. Here was a man who had been in Hissène Habré's jails and who could talk to the Senegalese public in Wolof. And the ICC, I'm always afraid, doesn't take advantage of victims that way. When the president of Sudan was in South Africa and there was that whole controversy of whether he was going to be arrested, you heard from the prosecutor and you didn't hear from victims. You didn't hear from Darfuri victims. I can't name Darfuri, people can't name Darfuri victims in general. And I think, when many years ago, on the Pinochet case, Roberto Garraton, who had been documenting crimes under Pinochet and was now the special rapporteur on Zaire, he said, Reed, under Pinochet, we had 1,053 people killed. I have the pictures and the names of every one of them. And people knew who they were. And to me, in that moment, and then he said, and I'm the special rapporteur on Zaire, I can't tell you if 1 million people were killed or 2 million people were killed. And in that moment, I realized that's one of the reasons why Pinochet can be prosecuted, because you know who the victims are. They're present. You see their names. You identify with their stories. God, I have a long way to go. Okay. Sorry. Anyway, but it also it also determined the contours of the case itself. In the beginning, the ICC, and this is on the first prosecutor, but when he went into the Congo, everybody was really excited in the Congo that justice is going to happen, and then they saw that he's going after one local warlord for child soldiers, which is a bad thing, but okay. But and the Chadian victims were always very clear. You have to take all the crimes. You have to take the crimes in the north against the Muslims. You have to take the crimes in the south against the Christian. You have to take these crimes. You have to take those crimes. And that's the way the trial played out. And the reason that sexual violence victims came and broke their silence was because their lawyer, Jacqueline Mudena, was prosecuting the case. And they didn't have to go before the glare. As they got on a plane to go before the glares of lights in an international courtroom in Dakar, they had their lawyer there. And so I think that, Terry Cruvalier, who, as you know, is a big critic of international tribunals, said never before in an international trial have the voices of victims been so dominant. And when people would watch the case back in Chad on TV, they would see their former dictator on trial. And not just because their current dictator wanted to put him on trial, which is the way things usually work in Chad, but because crazy people like Jacqueline and Suleiman had put him there. And that means my last point, which I'll do very, very briefly because I think I'm running out of time, which is outreach. I was here at the trial in Celle, Germany, a couple of weeks ago of a Gambian hitman, alleged hitman. Very important trial. For Gambians. It was quite an important moment. But there was no outreach at all. The proceedings are in German with no interpretation. The defendant has headphones to listen to it in English and Wolof. Those headphones are not shared with the public gallery. The Constitutional Court had to intervene in the Koblenz trial so that those headphones could be shared with accredited Syrian journalists, but not with the Syrian public. We've tried to make up for that. We have brought the victims and activists to Celle. We have a team of Kai Ambos's students there every day taking notes, and we publish them in Gambian newspapers. But it would be, and the case has gotten a lot of attention in the Gambia, precisely because justice process, which maybe we can talk about later, or maybe Hareja will talk about tomorrow. The justice process is in a very shaky moment in the Gambia. But imagine if that trial were televised. Interpret. I know this is so un-German as to be impossible. But people would be glued to their TV sets, and this would have a real impact. Here's this low-ranking third, and what does that say about all the people in Gambia who are not yet being prosecuted? And Jammeh be so much more important. And if you're going to do a universal jurisdiction trial on behalf of the international community, as the court of humanity, I think it would be really, very important. So those are half of the points I wanted to make. And anyway, I thank you all very much for your patience.
Thank you very much, Reid. Let me say this because we work on this for quite some time together. But one point that I would like to really support is how communication is important when dealing with these cases, because people feel like this happened so far away from us. So why do you want to dig again the past? Let the victim rest. May they rest in peace. They might be in paradise, etc., etc. But the minute you bring the voices of the victim, the dynamic change. And I think you were very, very good at it, among other excellent things you did. But I think that is a point to be taken, that you need to bring the public on your side. That's so important. Let me tell you one thing. Well, President Macky Sall himself, when he was attending some of his peer meeting, wasn't that comfortable, because people were just like, dear brother, so is Senegal safe for us to visit now? These kind of situations were and he would come back and say, well, this trial, how is it going? I could see that he was kind of nervous. So when you bring the public, you put more pressure also on national authorities. You bring a face to people suffering. And I think Reid, being an American are very good at, in LA with movies and all of that. But that really helped the case. That definitely helped the case. You're less isolated. You have thousands of people out there. Habre spent 25 years here. He was perceived as a very good Muslim who was funding mosque, good relationship with big religious families. So people were, well, why would you bother this old man? But the minute we passed the movie on his crime on national TV, then the dialogue changed. And then during the trial, hearing, rape victim, telling their stories, a massacre, I can tell you people was that he just deserved what he got. So I think this is a lesson, a very important lesson learned to be taken. Thank you very much, Reed. So let me just open up for discussion and question. We still have 30 minutes to hear from others. So the floor is whoever want to take it.
Let me just say that I have to get rid of these. These are like, describe what the whole saga that Mimi described yesterday about the Histon Habre case.
Could I just reflect on the issue of victims in court, because I think it's interesting.
Sorry?
Could I reflect on the victims issue that you raised? I mean, I agree to some extent, but one has to understand as well that a national jurisdiction needs to protect the victims in a way where we do not have control that we usually would have. In any Swedish crime where we know where the victims live, where the communities, we can protect them. In most of our international cases, the victims will have relatives in home countries where any identification of them can be troublesome. So keeping public trials is very difficult. In the Iran case, I think a lot of the victims would not want to appear. They probably wouldn't even enter the courtroom if that would have been televised. And I think that goes also to many victims of the Syrian context. With that said, we do have victims that have chosen to become very public, and of course that's good, because then they can come to the Congress in the US, or they can give an account of what they've actually been through, but that's their choice to do. Us being a national court and judiciary, we would probably be a bit more boring and try to protect everything and keep it close. In Sweden, the trial is public. There is audio recording that's allowed, but otherwise there wouldn't be no filming. And I think it serves another interest that we cannot sort of deny. And I think that interest sometimes would be higher to actually give those victims in that specific courtroom that needs to protect it.
But you can put in measures in place to do that. I mean, you can, even at the ICC, which are televised, or in the Habre case as well, there were two people who didn't want to be. But at the same time, when the victim, one of the things that so many people testified who were both victims and witnesses, but because they felt that this was their case, so many people said, one of the rape victims said, I feel so strong to be here today. There is that man sitting there who could do anything to us, and now he has to shut up and listen to me. That moment for me was like, that's why I do this. And okay, if they didn't want to, they didn't have to. But it's really, justice serves a lot of purposes, and I think we have to look at all the different purposes. But one of them is certainly to be transformative of the power relationships. And in that sense, by allowing that, you do it. I understand that the core purpose of justice is just to determine whether or not somebody committed the crime of which they're accused. But I think, particularly in universal jurisdiction cases, we're looking at more than that.
And let me just jump in on witness protection, because this is a real deficiency in this whole situation. On one hand, you have these situations where you do have individuals that come out or in danger, have information, and there's no court anywhere to protect them. I think of even the situation of Caesar, and we don't mention the country that he's in, but it was only because of a very aggressive diplomat that we got him and his family to that country and in safety. Otherwise, he'd be dead today. And that was just a volunteer act. But there are other people with information before you have a court with jurisdiction that are profoundly in danger. And as these cases succeed, they're even going to be in more danger. And national systems and the witness protection generally limited to the question of, anonymity when they testify or testifying behind a screen. And even then, there can be revelations as they describe their testimony that pretty clearly identify them. And we've had those situations, I won't go into them specifically, that have arisen in some of these UJ cases. And I think it does call for, part of the coordination work, part of the work of even a mechanism would be greater coordination on witness protection. Looking for ways, one, that you can fill the gap before there's a case and find even private philanthropy that could be available to protect witnesses with, international commission of experts saying this person needs it, et cetera. And then it was something else that we've talked about various times. But then once you actually do have prosecutions and witnesses that are needed in these trials, ways in which that can be achieved when countries themselves can't do it. So, I don't know who was going to recognize the, Jennifer, maybe you should.
You are in charge because I don't see anybody.
Note, if you have a question, you want to raise a point, please go into one of the microphones, and you will also appear on the video, and we will record your voice. Thank you.
Hi, everyone. Thanks for a terrific panel. Just following off on a point that Ambassador Rapp just made about witness protection and witnesses being sort of the soft underbelly of our system because they're so often under threat when they do come forward and press charges or participate in proceedings. I'm wondering if the panel could speak a little bit about untangling the idea of witness. We often think about witnesses as vulnerable, percipient witnesses, survivors, right, who are speaking about their own experience. But Ambassador Rapp, you mentioned Caesar, who under some circumstances could have been prosecuted as an accomplice, right? Because he was, for a period of time, part of the machinery of torture, industrial grade torture within Syria. What are the best practices and what have you seen about how states can respond to insider witnesses in terms of things like use immunity, immigration benefits, et cetera? Because they don't necessarily trigger this heartfelt empathy on the part of, diplomats, et cetera, or some of the protections that exist for human rights defenders to help get them out of dangerous situations and into a more stable immigration status. So I'd love to hear your thoughts about how to deal with insider witnesses in a way that feels both fair and just, ultimately, in terms of outcome.
Let's hear from Ms. Devgun.
I would say that I wish we could do more. In Sweden, we do not have a plea bargaining system. We don't have the discretion of not prosecuting, which could, of course, make it difficult in some cases where you would need high-level defectors to be able to move even higher up in the hierarchy. So that's something, of course, one could look into. I think when it comes to witness protections in general as well, we don't have. I agree with a lot of what's being said, and if we would have the measures to actually protect the victims, then yes, we could probably have more open and public trials, but we don't have that yet. And one has to understand that some of these victims are spread like over the entire world, and that there could be very strong forces wanting to get to them. So we need to do what we can. In Sweden, we do not have anonymous witnesses at all, which is a huge... especially in these cases, it's an impediment. So just to get someone in trial, that's our first priority, to get someone to testify. What's more being done? No, I would say not much, at least not in Sweden. We could sometimes, and that's important as well when it comes to the regional networks, and when we look together, there are, I would say, a very good legal framework within the EU institutions to do coordinated work and approaches. So what we already are doing is that if we do find investigations where there will be a link between different EU countries, you could have the perpetrator in Germany, you could have victims in another country. There is actually some sort of way to do forum shopping, basically. We could choose to, if I have a victim in Sweden that's very important to, let's say, Germany, and Germany has anonymous witnesses, the fact that we have so close connection between our units and that kind of interlinkage that we can have within the EU network, we're able to address that within the already existing framework, even though we in Sweden do not have anonymous witnesses. So there can be some solutions and we can be creative. But that also can happen because there are such close connection between these different units. where these sort of challenges can be identified?
I mean, this is an enormously challenging question, and at the international level, I think it's been less than ideal as well, and there have been very few insider witnesses in these trials, and very few of the kind of situations where a witness pleads guilty and then testifies in a very useful way. And so finding the ideal solution is very challenging. But I do think there could be an opportunity, for greater state cooperation and for the development of a task force that would bring in, for instance, immigration authorities, interior ministries, et cetera, into these kinds of questions. Because, frankly, in most of the situations where you've got a seriously, extremely important witness, and given the size of the world, you can find a place where that witness could be safe if you could have an immigration benefit. And I know in the US, we had a horrible time making trafficking cases, for instance, human trafficking cases, because you would end up in a situation where the individual who would testify about a trafficking case would then be removed back to the home country where they had been trying to escape. And so in the trafficking bill in 2000, we established a T visa, a trafficking visa, but several thousand of these that could be authorized by Homeland Security every year to basically give witnesses the right to stay in country to testify, maybe not permanently, but for a period of time, et cetera, and a work permit. And if they have that, of course, people would then argue, well, the reason the witness is testifying is because he's getting the benefit. We understand that. But the point is, you need to have that kind of opportunity, or the witnesses, frankly, by telling their story, are going to make their situation worse, and you can't rely on that and on a system in which people who actually come forward with the truth end up in a far worse situation if you're going to have a practical system of justice.
Oiso?
I don't have anything useful to add to the conversation other than to complicate it further. A few years back, I had the privilege of working briefly with a defense team at the International Criminal Court, and of course, all the challenges that are being mentioned here concerning witness protection, those are, they've been discussed. But one thing I noticed is the sort of imbalance in resources and approaches that between the prosecution team and the defense team. Because we talk a lot about how do we protect witnesses who have information that is useful and relevant to us from a prosecution perspective. But we hardly ever talk about what about those witnesses that would be actually very useful to the defense teams. First of all, defense teams already have, and this is not just an ICC problem, I think it cuts across the board when we're talking about international crimes, whether it is universal jurisdiction or otherwise. There's already an imbalance between the resources that prosecution has and the resources that the defense teams have. And the defense teams often have a lot of significant problems or challenges accessing their own witnesses and people they can rely on to put up a proper defense, because the whole idea is to have a proper defense if we are to say that the system is fair. So for those who are experienced, sitting here and everybody else in the room, because it appears as if I'm, quite truthfully, I'm the only one with very little experience in this room. So this is me throwing it out there to all those of you who are very experienced in this regard. What do you think would be some measures that could be taken to ensure that while we are having conversations about how to adequately secure and protect our prosecution witnesses, we extend the same grace to those witnesses that would be useful to the defense? Because if we are to talk at the end of the day of a fair trial, it's not only fair if the prosecution has access to everything it needs and all the witnesses are adequately protected, but it's fair if both sides of the aisle have access to similar resources. So that, at least, it may be not necessarily a question, but something to throw out there for us to think about when we talk about securing witnesses and protecting witnesses. Let's think about what this means for a fair trial, equality of arms, both sides of the aisle. Yeah.
Let me just jump in for a second, because there has been some positive experience in this area with the mechanisms. I'll sing the praises of UNITAD in this regard. In Finland, they were prosecuting suspects for killings at Camp Speicher in Iraq, and these fellows had an alibi defense. And so they went through the court, of course. The defense attorney got cooperation then through the court with UNITAD. One, to get location data from the cell phone company to show where they were at that time, and then additionally to have defense witnesses appear from Baghdad in the court in Finland. And they were acquitted. And the Finnish prosecutor, which of course prosecuting a charge and a décharge, I mean wanting to establish the truth, was extremely appreciative of that kind of assistance. So if we do have a mechanism, there is the potential. Of course, it's going to be through usually a judicial process to reach out and obtain information of benefit to the defense in situations like that.
I could also give you a bad example. Because I think it's a very important question, and of course there will be a challenge, and it's very important to be able to, within your own system, sort of structure your investigative unit to be impartial, to have the ability to interview even defense victims. We worked closely, of course, with the Nordic countries, and this was a case of extradition, but it related to extradition to Rwanda, where the defense lawyer in Norway went to Rwanda, I think on a tourist visum or something else, and he interviewed these victims himself. He tried to do it. He used a police officer from Norway who worked, I think, with narcotics to make it more legitimate. But basically, these interviews, they were horrific in the sense of doing fair and impartial investigations. And they interviewed these victims saying that we're coming from Norway, we're part of the defense. No, as I understand it, no admission or no approval from the authorities in the hosting country. Interviewing them, asking them, saying that whatever you say to us, we don't necessarily need to say to the Norwegian police. This led to the fact that the Norwegian Justice Department later ruled that there will be no extradition because it was not probable cause of the suspicion of genocide, because that there were different accounts from the victims, but then some of these accounts had been obtained by the defense. Some defense lawyers might argue that we need to do this because this is our only way to do our own independent investigation, but it does cause, there's no scrutiny, there's no way that we can control that this is conducted in a way that it would never happen in your own national jurisdiction, but it did in this. And I think we have seen that this is happening also in some of our other cases where the defense would go by themselves and try to obtain evidence. Of course, I understand the challenges. Especially if you're accused of a crime within a context where there could be a lot of co-perpetrators, you might not want to share that evidence to the police and say, go and interview these people, they can give me a valid defense. I don't have that answer. I think there's a challenge to that, and I agree with the defense lawyers, but I also think that the solution to just give the defense lawyers resources to do whatever they would like to do is not the best way to go about. It's not the best solution.
Can I say something? Just to Oviso's point. What I have witnessed, here with the Habre case, he had the most expensive lawyers for his cause. I don't think resources was most of the time an issue, because perpetrators are at the powerful side of the equation most of the time. So they can find the resources for that part. What I have seen is, on the contrary, I think the unbalance is on the side of the victims, of the prosecutor. They have powerful position. They trigger fears, in the victim's mind. They have a lot of money, and they can have the best lawyers. So if you really want to talk about fair trial, you have to sort of put more resources in the hands of the victim rather than in the end of the defense that can handle itself pretty well.
Matteo says.
So, is there any other question from the floor, from the audience?
Yes, there is.
Yes, please.
First, let me thank you and the panel for a really inspiring discussion. I would like to pick up on something that Reid maybe in a half sentence has touched upon, which for me is essential. And you mentioned costs. And we just see at the moment, at this very moment, an international tribunal collapsing simply because it's running out of money. It's not collapsing because it's running out of cases. Actually, they had already scheduled a new trial, the so-called connected cases at the Lebanon Tribunal, and then simply their funding dried out, and now they wrap up the whole thing, and it's going to be closed some course of next year. That shows that very easily the future of international justice may be not existent, simply because there is nobody paying for that. And that is something that I think is also an important element for the national systems to pick up these cases. You mentioned your own compatriots saying, why should we spend all this money on something in the neighborhood? And this is a problem that the judicial system in the world generally is nationalized. Each document in the European Union that is concerning judicial questions is starting with the competent national authorities. Well, almost all of them. So it's clear that where in other areas states were quite generous in giving away sovereignty things like their armies, their currency or whatever, in terms of judiciary, this is rather the exception than the rule. And I think this has a lot to do also with the payment. The European prosecutor is the first example maybe where we have a real cost sharing for European coordinated cases, and that could also be a model, because if you have a standing mechanism, you still need to have a standing funding for that. Otherwise, the thing might dry out if it's, again, based on monetary contribution or something that you cannot plan with. So I think that a huge part of strengthening domestic systems is strengthening domestic costs. While Germany and Sweden might be able to afford a case, I'm not so sure about Malta, Romania, or other weaker countries, even in the European Union, let alone in other parts of the world. And I think this is an important element. Many states will say, we actually would love to do that. It goes to our heart, but we simply keep away from it because we can't finance it. And that, I think, is a global responsibility and a global obligation to actually implement a global, a universal law with funding which is universally available. I would be keen to hear your views on that.
I could just give a very short answer. Because I think it's also interesting to remember that sometimes it's not always about the funding, it's about dedicated staff and appointed people. I think we were at the Genocide Network, and the prosecutor of the Koblenz trial gave us an account of this. And it's a massive investigation, but it was also interesting that the lead investigator, and probably one of the best core international crime investigators in Europe, Manuel, he said that at the end of the day, we were only a couple of investigators doing this for a very long time, dedicated. And I think that's important to remember as well. Sometimes the idea of cost, of course, building up a new tribunal, immense cost. But if you already have existing national jurisdiction, just to add an area of law doesn't necessarily need to mean that you have to have this immense cost increase.
Let me just jump in, both on the international and national level. I mean, when I was prosecutor of the Special Court for Sierra Leone trying Charles Taylor on the special venue of The Hague, I spent half my time raising funds because we were on voluntary contributions, and our judges frankly told me at plenary, if we run out of money, we'll let him go. And there was a time that we were within 25 days of running out of money. So it was, and it was running politics. I mean, we got Senator Obama to put $12 million into the budget when he was a senator. We would work in Parliament. We'd go to other places. We'd work against governments that were trying to starve us in the parliaments. So it was, it required that. And it's still, even in the residual mechanism, requires voluntary contributions, though they're getting some help from the UN General Assembly. But I do think it's important that we establish these courts, and increasingly we see it with the mechanisms now. The UN General Assembly is providing a budget. That wasn't happening with Catherine when she began her job, but 3 years later, thanks to the leadership of Germany and Ambassador Hushkin, who's not going to head the Munich Security Conference, but he is ambassador, fought very hard to get regular budget funding, which is now 14, 16 million, et cetera. 14? Only 14. 20? 17. 17. Good, great news. The dollar's worth more than ever before, so that's positive. But anyway, but it took that effort, and I think that's extremely important when we do establish these institutions that we have that. The national situation is very challenging. I mean, it's great that in Germany it was just possible to establish 2 units in war crimes prosecution, and then also in Meckenheim, and that shows the dedication of the German government, the Ministry of Justice, and others. In other places, that's not the case. And I mean, my frank opinion is the best case in Europe right now that could be prosecuted is in Austria of General Halaby, responsible for horrendous crimes in Raqqa. And he's in Austria, and there's one prosecutor working part-time on the case for the last 6 years, and they haven't acted, even though there's these stories in the New Yorker about, the evidence against him and the efforts to obstruct that case. But it's fundamentally not a question of the prosecutor not having the will; they just don't have the capacity. And there's no police assigned to the case, so all the witnesses have to be brought physically to the prosecutor's office in Vienna by NGOs. And I think one of the important lessons in terms of, and of course Eurojust and the network leads on this, though there's a really good report now from our friend Howard Varney out of South Africa about the need for specialized units, and that every country really does need specialized units. We've had challenges of that even in the United States. We had a specialized unit, but the FBI was going to be pulled out of it. And of course the answer is always, we're going to mainstream this within a larger division. Well, the mainstream means it's ignored. It's the last priority on the list because these cases are complicated and hard, and you're not getting the stats that you would in enclosures otherwise. And so fundamentally that cause, wherever people are involved in a political process, that you need these units, and frankly they can be sold politically, particularly with a no safe haven attitude in most countries where the right wing doesn't want terrorists or criminals allowed in the country, and people on the left want human rights vindicated. So in Canada and elsewhere, people like Irv Kotler led that effort and got some permanent funding. But that is a challenge everywhere, but it's something that requires political activism by NGOs at the national level and by citizens if the system is going to work. But it's all part of the ecosystem, as I say, which needs at every level, cultivation and nourishment.
All right, let me give a chance to other speakers for the last maybe comment. Oviso, any comment? Oh, we have Catherine. Well, please.
Maybe just one remark concerning the issue of protection of witnesses in the very specific context of this element of the ecosystem that you referred to, Stephen, which are the mechanisms like the IIIM. Well, of course, we have a mandate to support, to facilitate justice with ongoing investigation, and there we can turn to the systems of protection of witnesses that exist in the national, or it could work as well with an international court that has that system. But we're also meant to build, to preserve evidence for future cases. And when we are to secure evidence from witnesses at particular risk, obviously having the possibility of recoursing to state witness programs that exist and that would be willing to consider on a case-by-case basis a request for witness protection, absent any immediate avenue for this witness to testify in court. I think we really see that as an important issue for us in terms of credibility as well. We're not lying to our witnesses. They know that we have very limited opportunities in this respect. There is one legislation in Belgium that provides for such a request to be made. Still quite a lot of work to do to make that in practice, and we have a state that has indicated willingness to consider on a one-to-one basis this kind of request. But that's not the network of solutions that you would need to be really able to deal with very significant issues of witness protection. We heard from the German prosecutor Dusha yesterday that these issues come up during trials, and as you can imagine, they come up prior to trial as well. So that was the first remark I wanted to make, and maybe if you allow me to go back for a second on the issue of recording. So I totally get the divergence and logical concern of the willingness on one hand to have those witnesses, those trials broadcasted, on the other hand, then the protection of witnesses. But even if there is a concern about witness protection, I think really for those trials that are landmark trials that are going to be extremely important for humanity, not just the communities in the country where the crime occurred, but more generally to all of us, I really think that the possibility of recording, even if you're not going to broadcast it live, and maybe that requires engagement with the victims, survivors, and other witnesses, see whether particular measures need to be made before making it available, or even retaining it for a period of time, up to the time where maybe the person in power in the country are no longer in power and cannot influence the security of witnesses. That, in my view, is a really important aspect to take into consideration. Thank you.
Thank you very much. Now I think we may want to go back to the panel for their last words, and then we might
have
conclude. We have 5 minutes left.
Yes, apologies for keeping you.
Okay, well, I'm not seeing people, so I cannot know.
Hi.
Yeah.
I think we have still some 5 minutes, and I would just like to go back to the costs and issue of funding. And I would say that, of course, resources are needed to start the work and so on, but a lot can be done with quite limited resources. And I think often countries would say we can't do much because we don't have resources, and not even trying to do much, and use that as a sort of excuse. But I think, as I said, a lot can be done with existing principles and basically, of course, money or available funding that is there. And I would just say maybe the testimony to this would be the Genocide Network, which currently runs with 4 staff plus 65,000 euros. And I think any region can afford this kind of costs to put together. And it used to run with 1.5 staff and 60,000 euros. So that's a peanut in a total global fight against impunity. But I think it's really the commitment, the motivation, as Rina was saying. You can do a lot with 2 or 3 investigators and 1 or 2 prosecutors, even if they're only there part-time, and do also other serious organized crime next to that, but at least to dedicate that, to mention that as a sort of a policy on level of Prosecutor General Office. Hey, we will do these cases, and yes, I'm allocating these 2 persons, next to the other work, but when the case comes, they will be trained, they will know who to contact, and they'll be able to react. So I think that's something that we often forget, what can be done with the willingness and motivation. And I think here I need to actually pose a short question to all of you from the panel. I would like to see other regions to set up similar networks. And of course, there is a great willingness within the EU Genocide Network to support setting up other regions in creating similar sort of community of practitioners to discuss this. And here would be an immediately question to all of you. How would you see what could galvanize this support, so that also maybe some African countries could start it, some Latin American countries could start it, some Asian countries could start this? What would you see as that trigger in this, you said victims, of course, but the victims need also legal framework, and they need to know who they can contact. So that would be basically a question, and also to you, Madame Touré, a moderator from Senegal perspective, that would be also a question to you. Thank you.
Thank you very much. I guess the discussion will carry on, but I have some constraints, and we have few more minutes to let the panel wrap up. So I like to turn the floor over to Ambassador Rapp, and then Ms. Refkoon and Osiwi and Reid before I completely conclude. So Ambassador, the floor is yours for your last comment.
Well, I mean, there are a lot of issues that are out there, but just to focus for a moment on what Mateus was saying and what Luisa was talking about earlier, I mean, I'm extremely excited about the possibility that we could get this going in other regions. And recently I was in Gambia, but then went also to Sierra Leone. We were hoping potentially to have for President Yahya Jammeh and others out of the TRC process that we'll hear more about tomorrow, but potentially a special court established to try him so that we wouldn't have to deal with head of state immunity and the 2/3 vote that's required in the Gambian constitution to try a former president, and we could have a court that could pass a statute that would include sexual violence in proper form and torture and other things that would be hard to do nationally. And the idea that we could establish a special court with ECOWAS and perhaps Gambia, maybe with trials in Sierra Leone at the former site was something actually in Sierra Leone they were very excited about. But what really excited me is I was visiting the Minister of Justice, and during the course of the conversation in Freetown, the Solicitor General said, well, why stop there? Why can't we have an ECOWAS criminal jurisdiction court headquartered here in Freetown? And I said, fantastic, that's the best idea I've heard all day. Let's see if we can make that happen. Obviously, that requires the will of Nigeria and other countries that are ready to do that. But, you know, make Freetown the Hague of West Africa. And do that in other places, I think would be the kind of step that would be extremely important, and we should be pushing for it. But the frustration that we've had, and the key example of it is the hybrid court for South Sudan, where it was to be entirely African judges. It was agreed to twice in the peace agreement. It could have been put into effect by the African Union without necessarily the consent of the government, because that had already been provided in the peace agreement. My own government provided several $1 million to the African Union, and they raised other funds as well that would have permitted the hiring of many great people that have worked in Africa as part of a planning process, and the African Union refused to put out vacancy announcements and actually begin that planning process. And so, you know, it was that political barrier, that sort of protection of various leaders by other leaders that made it impossible for it to occur. And you know, how to break out of that, I think is an enormous challenge. Obviously, it was accomplished by the whole process that we saw in Senegal in that one case. But let us, you know, continue to mobilize and to mobilize civil society around these efforts, because I agree completely that the justice is better when provided you know, as close as possible to the victims and to the affected communities. And finally, I just wanted to say the one thing about Reed, and I know I'm sure it's in the book, but what I've always said about Reed and about that whole process, and obviously Suleiman Gang and Jacqueline Medina and Mimi Tori and all of the things that made this happen were extremely important. But one of the key parts of it was the evidence and the quality of the evidence, some of which had been gathered by the Truth Commission in Chad, but it was consolidated, and some of these fantastic documents found during your mission in N'Djamena in 2000, I think, or
2001, yeah.
2001, including documents in Habre's own hand about nobody leaving this prison alive. And that evidence was so strong that a Belgian prosecutor, long ways away, looking at a lot of other cases that weren't so strong, said, this is the best case we've had in here in a long time. And so the fundamental point of this is whether in that case it was civil society to some extent with the work of a Truth Commission beforehand, but to the extent that there are these contemporaneous activities and there are victims organizations working with international experts and bringing forth that evidence and preserving it, that when you've got the evidence, eventually you can beat down the door and find a court to take it to. And so the fundamental part of this whole ecosystem that needs the nourishment, needs the reinforcement, whether it's done by civil society or national prosecution authorities, is that ability, or by mechanisms or UN commissions, is that ability to gather the information, preserve it, and have it done by people that understand from an international law perspective, what's probative, what will allow you to assert command responsibility or joint criminal enterprise or other forms of co-perpetration and win your case in a criminal jurisdiction throughout the world or at an international court. And that is, at the end of the day, the most important and essential element to the whole ecosystem. And without it, even the best international court will fail and acquit even individuals that everyone frankly knows was responsible for the crimes.
Thank you, Wiso.
Yeah, thank you.
Any last comments?
Yes, my last words, I'll first start by responding to what Matteo said, asked on Genocide Network, networks elsewhere. I think when trying to establish some of these networks outside, because I believe there's already one that you're working on for the European continent, if you want to have similar networks for other continents, let's say Latin America, the region, and the African region, I think it would be difficult to say you're going to do this with, let's assume, the 55 states. I think the first steps would be to identify the few states, because I believe there are always a few willing states. So to identify the one or two very willing states and start from there. You start small. We start small by identifying who are the willing parties. Out of, let's say, 55, you could find one or two who are willing to start. So great things start from somewhere. So first identifying the few who may be willing to buy into the idea, and then we build from there over time, right? And then my final remarks would be on funding, on costs. Good intentions alone do not go very far. Things require money, and they are expensive, of course. So then going back to one of my main issues that I discussed earlier on innovative thinking and thinking out of the box, looking beyond the traditional actors. I think if you look around, one of the most consistently funded mechanisms around these days is the Kosovo Specialist Chambers, which has been consistently funded even during its initial years when it was really doing nothing much other than consolidating its evidence. It's consistently been funded by the European Union. Why? Because it was an approach that was, it was given a regional approach by a regional organization, right? So I think that, if you look at the Special Tribunal for Lebanon, for instance, because the tribunal was relying on, a UN-style sort of funding mechanism, willing states and all that, and all the others challenges, ICTOI, ICTR, the challenge has been that getting funding from the UN system is also subject to the whole political, political maneuvering of the UN system. So if we decentralize this and say, let's look at regional organizations. There may be, fewer interests, fewer political interests there that could be, it would be easier to galvanize that, so to speak. And for this, I haven't worked with NGOs, but I believe NGOs are very good at PR. So I think this NGO-like PR could be used to target particular actors such as regional organizations and even states. So when states, for instance, when Senegal said, we cannot afford this, that to me would not necessarily be true because, the GDP of Senegal, it's not that they could not afford to fund it. The question was, what is in this for us? So I would approach it the same way I would, if I'm an investor, I would approach a business venture. What is in this for me? I may not necessarily like the business and human rights angle of things if I'm an executive on a board of a business, but I would ask, okay, good. So you want me to do this business and human rights initiative. What then is in it for me? So come to me with you're going to get money out of it anyway, but my primary concern is, of course, the business and human rights angle of it. So we approach states, for instance, and say, Senegal, if you fund this particular mechanism, yes, it's good for accountability purposes for the victims and all that, but for you as a state, the PR is going to be good for you. And I believe that's what got the EU sold, because the EU is getting very good PR for itself, of course, for involvement in Kosovo with the EU legs. I don't necessarily believe that the EU is very altruistic. It's very, like we want to do this out of the goodness of our collective EU hearts, but there is a particular PR angle to it. So I think it's identifying non-traditional actors and giving it a PR approach. Maybe that doesn't necessarily sound very, very cool, morally speaking, but you have to get the money somehow. Yeah, I think I'll stop.
Thank you. Ms. Devgood?
Yes, thank you. Well, I think in the long term, the national units, they need to be established in each country to get somewhere, to have long-term effect. I do agree that there could be a need of tribunals and special chambers, but I think building up national units will be the long-term, most effective way to sort of exercise jurisdiction and the impunity. And I would say to Mr. Raff here that Austria might not be the best example. Finland, I think, only has 2 or 3 prosecutors, and they've done quite a lot with a very, very tiny unit. So it doesn't have to be a very costly question. And to answer you, Matthias, I think it is very, I think the EU example is a good one. It doesn't need to be the best one, but of course I think many of my colleagues would be most willing to share their experience to anyone interested to listen, and I really agree with the Lisa. You don't necessarily need the whole African continent to have a EU Genocide Network, or EU Genocide Network. In Sweden we have, in the Nordic country, we have a Nordic network. So start small and build up on with that. I think that would be a good way forward.
I'll be very brief because I want to see the courtroom. Just the cost point. I mean, as Aminata described yesterday, we had raised $10 million for the Habre court when the ECOWAS court said, you have to build an ad hoc international tribunal. And we said, for $10 million? And the African Union did. $10 million. And they did it by basically saying, voila, this Senegalese court is now an international court. You're going to apply international law. We're going to throw in 2 international judges. And what I learned from that experience and from creating the court is that you could purpose build. Immunities are not known in Senegalese law. You have to prosecute everybody. They put immunities for insider witnesses. Trials are not televised in Senegal. They put in televised. Command responsibility, put in command responsibility. And that's something that Stephen has really hammered away at in his trips to Gambia, one of which I should add was by pirogue, when the ferry had broken down over the Banjul River, so over the Gambia River. And so and I guess Harej will talk about this, the idea in Gambia now is to have a hybrid court with ECOWAS, which as we know has been very involved in Gambia. But as Steve keeps pointing out, the more domestic you make it, the less expensive it is. Anyway, thank you very much.
Thank you very much. I mean, justice costs money, that we know. And, you have to make a case for putting part of your already insufficient national budget into a grand cause that deserves international justice. It's not a given, believe me. People would tell me, well, we need money, to build more tribunal. We need money to accelerate justice processes in Senegal. Why are we going to put that money, to prosecute victims that are not Senegalese and a state of hate that is not Senegalese? So they have a good point there. I mean, you can understand where they come from. So let's not take it as a given that no matter what the amount is, you can find it in national budget, because there are so many competing urgent action to be taken. But we do need money. That definitely we do need, and I think it brings the points about solidarity. And this ecosystem that we agree upon, Ambassador Rapp, needs to be funded, needs to be protected, needs to be expanded. We talk about partnership. We won't succeed if we don't bring our resources together. Are we going to make sure that we can build upon regional mechanisms that exist? We also talk about the ECOWAS, the Council of Europe. These are ideas that we have to work with to make sure that we get the best out of what is already there and we save what we already have. So we definitely need to work together. We need to be creative and innovative. I think that's what we have done in Senegal. As Reid just said, I mean, for magistrate, I mean, seeing a camera in their court was unacceptable. So, but we have to work with them. We have to tell them the purpose of why are we doing this. We also need to train our judges. We didn't speak a lot about that. But within solidarity, I also put the equation of training. Criminal law is not necessarily taught in universities, the way we understand it. So that is a piece also we need to build upon. Yesterday, I talked about, a network of national prosecutors on international crime. This is also part of the solidarity we're talking about. and the voices of the victim. Of course, it's not about compromising 1 second about their security. That is very, very, very important. But it makes a huge difference, I do believe. And I think we have sophisticated method of protecting them. But the minute you hear those who suffered, those who can explain, let's agree that the topic we are talking about is very sensitive to politics. And until we deal with the politics, it's going to be very difficult to make progress. So I think we need to use the tools that are in our hands, including communication tools, to make sure that we can pursue justice for this victim without compromising with their security. That is obvious. I do think that if we are still, having the memory about the Holocaust, it's precisely because of that the memory of the human that we are is still nourished with what should never happen. So I think I would very much advocate for that. So we will need to get out of the court system and link up with other resources that can support international justice. One point I would also like to make, which is very dear to me, is how can we also open cases on sexual violence? We know as international crimes, they are so prevalent in war contexts, but at the end of the day, victims take it as, well, that was part of the ordeal. I still survive, so it's not that grave as those who died. And I think that piece also needs to be brought in. So this is what I wanted to say. So thank you very much for all this reflection, and I will wish you a fruitful reflection for the 2 days to come. So best greeting from Dakar.